Welcome, folks, to this latest webinar in our series at George Washington University Law School. Very glad you could join us. We're very honored to be joining today our colleagues at the University of Turin, where many of us are here in Turin in Italy, and we're delighted that we could do this program with them. This webinar, is an extension of an all-day symposium we've had here, and some of our colleagues will be referring to conversations, very interesting conversations we've been having during the day. The slides from that earlier conversation will be shared on the program page at Public Procurement International in the next couple of weeks. And again, I'm very, very grateful that our colleagues at the University of Turin were able to hold this session with us. We're experimenting. We're doing a webinar where many of our speakers are in the same room in order to improve audio and video. I want to thank in advance my fellow webinar panelists for their patience in going forward in this. I'm going to give a little quick bio on our speakers before I start out. And Gabriela Racca, who is my colleague here, who's the co-head of the symposium. She's our very generous and gracious host here at the University of Turin. She and I have done a number of books and a number of symposia together here and joint efforts between GW Law and the University of Turin. We have 3 panels today, and they're going to talk through issues in AI and public procurement transformation. And after their presentations, we are going to have a more open discussion. In advance, you should know that Jessica Tillman won't be able to stay throughout the whole program because she has to teach. And we're going to try and wrap this up in approximately 90 minutes. So let me go through the introductions first. Jessica Tillman, she's the Associate Dean and a very cherished colleague at the Government Procurement Law Program at the George Washington University Law School. She's a leading authority on public procurement, corruption, and AI governance in the public sector, with a particular focus on integrity, compliance, and emerging technology risks in government contracting. She's published extensively on AI and public procurement, and her articles are available on jessicatillman.com and on the resources page for today's program at publicprocurementinternational.com. Jessica, I should note, is also extensively quoted in our national and international press on issues of AI and public procurement. She's been very active in that regard, and she's been a very important voice in the adoption of AI in public procurement in the United States and internationally. She teaches in anti-corruption and compliance and is co-editor of the Rutledge Handbook of Public Procurement Corruption, a comprehensive reference on corruption issues and enforcement in public procurement systems worldwide. She was the co-editor with Shope Williams, who's our very dear colleague at Stellenbosch University. I should note that Shope will be joining us at George Washington University Law School. We're very excited to have a new colleague joining us at the program at GW Law. Jessica's scholarship and commentary address legal and policy issues related to public procurement corruption, AI and emerging technologies, government ethics, white-collar crime, and compliance. We'll also be joined as a panelist as Luca Martinelli. He's an official of the European Commission. After completing his PhD in political science at the University of Florence, he undertook research at the University of Bologna at the Center for Public Policy Analysis in the Department of Organization and Political Systems on projects related to public administration and public policy analysis. After that, he joined the European Commission. He's now the head of the Publications Office of the European Union. He'll be talking about new initiatives in transparency through the European Union. The Publications Office takes a lead on that. His experience as researcher and policy practitioner ranges across issues as diverse as environment, transportation, public health, broadcasting, ICT research, and deployment. Finally, Caroline Nicholas is joining us. She led the work of the UN Commission on International Trade Law, or UNCITRAL, in reforming its model law on public procurement. She and I worked extensively on that. It was wrapped up in 2012, and as I should be discussing, UNCITRAL is now reopening the model law for review and possible revision. Caroline was speaking on how AI may reshape the UNCITRAL model law, which should be reopened officially probably after a session this summer. She provides technical assistance to national governments in all regions and works with many international bodies such as the World Bank, the EBRD, the WTO, OSCE, and OECD on commercial law and policy and reform. She also teaches in public procurement law and policy at the postgraduate level in several United Kingdom and European universities, is a member of the editorial board of the Public Procurement Law Review, and is published widely on public procurement law and policy. She also leads internal investigations and advises on disciplinary administrative issues in the UN system. She previously advised on international war damage claims at the UN Compensation Commission, and she's practiced commercial law in the City of London and Hong Kong. She's also solicitor of the Supreme Courts of England and Wales and of Hong Kong, and holds various governance posts, including as a member of the board of the Open Contracting Partnership. Open contracting is an issue we'll be discussing during the course of today. So with very warm welcome to our panelists, and we'll also be joined by other members of the symposium from today, and I'll be introducing them later on in the program. So if we could have the next slide, please. Next slide, please. So actually, let me just do a quick introduction of our fellow symposium members here. Laurence Folliot-Lalliot is a professor at the University of Paris in Nanterre in Paris, France. Stéphane Della Rosa is also a professor at the University of Paris at the University of Paris-Est, Créteil. Patricia Valcarcel is a professor at the University of Vigo in Spain. Andrea Sundstrand is from Stockholm University in Sweden. Anna Maria Lachimia is a colleague from the University of Nottingham, really our sister program at the University of Nottingham. And Elisa Niewin-Damska is senior counsel in legal transition programs at the European Bank for Reconstruction and Development. Unfortunately, two other colleagues were not able to join us, but we're very excited that the symposium members, many of the symposium members from today, are going to be able to join the general discussion at the end of the presentations. Next slide, please. So I sort of set the table here. I wanted to talk a little bit about the fact that we tend to think of artificial intelligence as a distant goal, as something that's separate from traditional procurement issues. But that's not really true. It's very much integrated. And I just want to give a quick example here from the traditional issues, how they fold into AI. So one of the issues that we discussed today, for example, was how we deal with the question of access to the dockets that are such an important part of bid challenges. If you accept the assumption that bid challenges are really a red flag for the worst procurements in any given system, the dockets or the claims that are being made in those bid challenges are a very important source of information potentially on what's going wrong in the procurement system. As a practical matter, and we'll be writing on this as a professor's consortium, as a practical matter, oftentimes those dockets or the claims that are being made are not publicly available. And yet, under principles of open contracting means everything should be accessible, everything should be machine readable. That's a real problem. AI, in many ways, makes the problem much more profound, because if AI is going to be used to track and assess emerging problems in a procurement system, then it's very, very important that those dockets be transparent. So we have a traditional problem, which is bid challenges, a traditional issue. Open contracting means that we should have as much transparency as possible, and AI accentuates those issues, essentially puts those issues on steroids. So very much AI is integrated into the traditional types of analysis we're doing in public procurement law. I'm very glad to see that Stephen Van Gars was able to join us. He's at Hasselt University in Belgium. He's a professor there. Stephen, welcome, and I'm very glad you could be here for our discussion. Okay, next slide, please. With that, I'll turn it over to Gabriela Rocca.
Okay, thank you very much, and thank you very much for being here, the colleagues and friends that are here and online. But we have the need to focus a little bit on how disruptive is the AI on procurement. So the idea is how we pass from the whole idea of e-procurement that we had in the directive since more than 10 years to agentic procurement, to AI, how reshapes the procurement process. So this is a real fundamental change that we have discussed this morning, but we wanted to put on the table now, especially but as the public demand is reshaped, and we have to imagine of how the analogic process that till now has been transformed just from the paper to a procedure on the computer must be rethought in a very, very deep way. And I mean, and one example just to discuss with you immediately is the AI qualification of economic operators. How, for example, in the next reform of the European directive, we can overcome the idea of having 50 certificate to be self-declarated and then to be checked. So the idea that the qualification of supplier under exclusion ground or qualification grounds should be evolved through AI instruments. So this is an issue that is really important to be at stake. The same, and we will have then probably also Jessica that has written very interesting thing on AI award, and so how this reshapes competition and the principles that could define how we get to the decision or economic operator to which award a contract. So the radical change that we have to a new kind of platform where we can do procurement in a very new way. But this change should not be compromise the principles. So to the next slides, we can just see how we can consider the traditional idea of desiderata in the procurement in any country around the world is affected by the AI as the game changer. But we have to decide that we change the process, but we have to save the principle. We have to rethink about the principles and how the principle will be maintained, maybe evoluted, but through a radical new process of the award procedure. Thank you very much.
Next slide, please.
All right. Okay. I'm just going to go ahead and go. Good afternoon or good morning, and wherever you're joining us from. Thank you for allowing me to be here and talk with you today. I'm sorry I couldn't be there in person, but as Professor Eugen's already said, I have to teach class in a little bit. So I've been writing a lot about AI. I fell in love with the topic about now it's going on 5 or almost 6 years, about the kind of the earliest stages than what we know of AI today. I first got excited about it because of its ability to reduce risk, and only in the last few years have I increasingly become more concerned about its ability to exacerbate risk. So most of my writing has been focused around integrity and how to use AI both to reduce risk and then also how it can create risk and how we need to mitigate that. If you want to go to the next slide, please. So the background of all of this is there's been a lot going on in the United States over the last few weeks related to artificial intelligence. And a lot of it starts from this concept that, there's 2 ways to look at artificial intelligence. One is, and the framing that I like to use is risky buying equals risky deployment. So many of us in the public procurement field are more comfortable analyzing what I call the use of AI or AI for procurement than we are the procurement of AI, because the AI procurement, using AI for the procurement process, using it to draft a solicitation, using it to evaluate a proposal, it is easier for us to wrap our heads around unless you have a technology background, because it's effectively making a machine or a tool, using them in place of a human for tasks we've always delegated to humans. The other side is the side I've been focused on both, but I am also very, very interested in the buying side, which is far more technically difficult to understand because you have to understand every aspect of the supply chain in artificial intelligence to truly understand the procurement of AI landscape. And so, what I want to focus on today is both sides. And what's challenging about artificial intelligence is it takes everything that we've known in our careers as procurement scholars or procurement lawyers, and it effectively inverts it. Rather than transparency, we have opacity. Depending on what's contractually negotiated, we may not have audit rights or even oversight. AI is that kind of well-known black box. And a lot of the things that we know, it changes, it drifts, it hallucinates, and it makes it clear that it's just not another tech purchase. But again, a lot of what we do at the front end in terms of the procurement of AI dramatically impacts how it can be used in deployment. If I can go to the next slide, please. One of the biggest issues facing the United States right now is this kind of flip-flop or ping-pong approach to AI governance. Last summer, we had very much a hands-off approach in the United States with our AI action plan. As I joked at the time, we had almost no governance, right? We truly wanted to defer to the procurement vehicle as the model of governance, what we call regulation by contract, which in my article, Buying Blind, I state is a profoundly inadequate way to govern artificial intelligence. This is something that our colleague Albert has also written about extensively. And so ultimately, this was the US approach as of last summer. By January, the Department of Defense issued a memo effectively directing the Department of Defense to acquire artificial intelligence for any lawful purpose and to ensure that we are buying models free of usage constraints. Now, let's take that and apply it to a normal procurement context. Imagine a government is acquiring a helicopter, and the government says to the vendor, it must be free of usage constraints. Helicopters have many usage constraints, certain altitudes, certain safety protocols, but instead you have a government saying you can't restrict how we're going to use it. And that is effectively what this memorandum said. So we moved from no governments to a memoranda that effectively said governance is a blocker, and then our governance adjacent policies are a blocker, and also said it had to be free of usage constraints. This application broke down when it came head to head with Anthropic, who many of you may use Claude. And what occurred is basically in previously negotiated agreements, and Anthropic, what we know publicly is that Anthropic has a very large vehicle. It's called another transaction. We don't have enough time for me to describe what that is, which is just outside our traditional federal acquisition regulation. And it's also a subcontractor to what we call prime integrator, to the prime contractor Palantir, in something called the Maven, in Palantir's Maven system. And so Anthropic's usage constraints, discretionary usage constraints, said you cannot use our product for surveillance of Americans and for autonomous weapons, right? We want to make sure there's a human in the loop. This was the usage constraint. That came to head because the Pentagon didn't want those restrictions. Now, some of us will understand that we can agree that we don't want something that's going to shut down in the middle of an operation. But this is where it becomes technically challenging because as procurement professionals, we can understand that we don't want governments procuring things that will be restricted in a way that can put our military in danger, that can hinder operations. But at the same time, it gets to two issues. One, it tries to override the discretionary policies of a contractor that it had previously agreed to. That we can understand. But the other part is the technology. The technology, it's all about the safety stack, which I'm going to get to in a second, which is very fascinating from a procurement standpoint. But in response, because Anthropic wouldn't back down, they were threatened to be designated as a supply chain risk by our government, which effectively blacklists them. And they have gone since and done that. It has led to extensive litigation, and it's basically everything's being fought out right now. It follows no known process. It was announced by tweet. I don't know what we call those these days on X, but tweets, I guess we'll go with. And we're going to see that play out in real time. Next slide, please. This gets us to something that's fascinating from a procurement standpoint. If your procurement contract, the government, and increasingly governments may look to this model and say, well, we don't want to buy AI with restrictions. If they decide to override the discretionary policies, what does that mean? And you have to start to understand what a safety stack is in artificial intelligence. A safety stack is effectively those policies, and it usually at multiple layers within the model. It can be policies, it can be system instructions, it can also be into the training of the model itself. It basically says you can't override our use of this for any lawful purpose. And I'll give you a good example of what the safety stack is. When I was, and it's in one of my new pieces, but when I was researching the best way to get my daughter's ears pierced for her birthday, I lazily tapped into ChatGPT. What's better for kids, a needle or a device? Now, that was just a silly way to phrase that question because ChatGPT stopped me and said, why does this person want to use needles or devices on a child? And that's the safety stack. So those are the discretionary refusals. Some of them are because of safety, some of them are because of reputational harm, but they are discretionary. And what this effectively does is it removes it. Now, OpenAI has since come in to replace Anthropic and has said that their line in the sand is any lawful use as well. But they believe that their safety stack, these kind of the technological aspects of their model, will stop it if it crosses that line. And I think we're starting to see in real time how that's actually going to play out. So this is going to be tech versus procurement playing out in real time. Next slide. So finally, what we're starting to see as well is that this is now moving from the Pentagon to our civilian side of purchasing in the federal government, that the AI system is not permitted to produce outputs based on their discretionary policies. So there's a proposed rule that is out. I have a piece out as of yesterday that analyzes it, that very much also perpetuates that any lawful use, no usage constraint posture, which really is trying to assert a greater ownership stake in AI that is used or performed or developed for government use. And so we've really seen a dramatic turn in the last few months between this kind of hands-off regulation by contract, no law, defer to the tech vendor policy, all the way to this now where we're now dictating if you want to do business with the US government, you need to give it to us free of usage constraints. And I do wonder that as companies adapt to this new reality, whether it has that kind of reverse Brussels effect, that it impacts how they approach procurement in other countries, how other governments see this happening, and how whether they are going to start to see it necessary to effectively sell or acquire AI free of these usage constraints, which is going to create problems because, as you can imagine, if some of those constraints are in there for safety purposes, for legal purposes, for reputational purposes, I think there's going to be a time when these start to conflict, and I think we're watching it play out in real time. It's far more complex than this. The GSA clause that just came out, our new rule related to AI acquisition, is incredibly broad. It's 9 pages long, and it's worth looking at because I know that governments are looking to each other right now to make these decisions. Okay, so with that, I know I'm probably going longer than I needed to, so I'm happy to answer any questions you may have.
Thanks very much, Jessica. Jessica, we just want to ask a quick question before we let you go. Is the European Union is reforming the directives, the procurement directives, and under the current rules, under Article 57 of the main directive, if there's gross professional misconduct, then that's a possible ground for exclusion, and that could be in another country as well. Do you think that the Europeans should view what Anthropic has done here, what they're being blacklisted by the Defense Department? Do you think that they should view what Anthropic has done, which is set these requirements, for which has made the Trump administration very angry? Do you think that that might qualify as gross professional misconduct?
No, if anything, I think that Europe will look at that and think that it's a company that has sound discretionary policies. I think that the supply chain risk designation is universally perceived by many legal experts, myself included, as legally dubious. It was a attempt to It was a negotiating tactic. I believe that they used it as a threat to get Anthropic to back down. And when they refused, they did it. It was announced first by a presidential directive by tweet, no government use. It was seconded by a message from our Secretary of Defense, who then also announced it by tweet. As I said in a piece that's actually going to be out on Lawfare today, and as I tweeted yesterday and didn't realize that to get picked up so quickly, we don't blacklist by tweet. In the United States, we have due process protections. We have independent suspension and debarment officials. If no one's saying that the government has to contract with Anthropic, but the answer is not to designate them a supply chain risk. It is to simply not contract with them or to terminate that contract. And even if they still did not want to do so, the appropriate mechanism for excluding a company from doing business with the US government is under Federal Acquisition Regulation 9.4, where they'll get notice and an opportunity to respond and potential judicial review. They were given none of those things. And so what we are now seeing is what I've publicly stated, and as I can state here as well, is that they were directed by tweet. The agency reverse engineered a legal explanation for the determination. It's now being litigated in real time, and many of us fully expect that maybe even in part a preliminary injunction will be granted probably next week, given the harm. And we think that Anthropic is very likely to be successful, given that this statute that was used was never designed for this purpose.
Thanks very much. So as the Europeans move towards, and there's pressure from the Parliament and from the Council here to the European Parliament to move towards a system of cross-debarment. It's a really interesting case, Jessica, of cross-debarment. For cross-debarment to work, we need three things. We need to know who's debarred, Anthropic. We need to know why and how. And this case teaches us you really need to know why and how in order to make cross-debarment work effectively.
Yeah, and I will also mention just one quick thing about the cross-debarment piece, which I think is important, is that one of the greatest things that we're starting to see is just the most incredible, it's not new, but the most incredible people working with data and different tools. I've been working with an organization or been talking to an organization, the Program Integrity Alliance here in the United States, about how we can better utilize that information. So for example, if you are a country in Europe and you want to understand if a potential vendor that does business in the United States is blacklisted, if you currently go to the website sam.gov, which is where we list it, there's no rationale for it. And you would have to do your own digging to figure out why it happened. And so we're starting to see experts in data figure out ways to scrape that data to connect the dots for people and make more usable formats so that companies, countries can do better due diligence and make those determinations.
Thank you again. Jessica, teach well. Have a good day. Take care.
Thanks
Bye-bye.
so much, everyone.
With that, if we could turn it over to Luca. Luca, welcome.
Hello, good afternoon, good morning to everybody. Greetings from Luxembourg.
Thank you for being here, Luca. The floor is yours.
Thank you, thank you. So thank you, Professors Racca and Jukins for the invitation. I would like to present to you how AI is reshaping also TED. I don't know how familiar the audience is with TED. TED is the official journal, public procurement of the European Union, where every day 4,000 public procurement notices are published. So it will be a very practical presentation looking at the following topics. Next slide, please. I will provide you first some background information about what's going on in the EU on public procurement, and also how the European Commission, the Publications Office for which I work, is part of the European Commission, how we are using AI. And then I will have 5 cases, case studies, let's call it like that, 2 of actual implementation of AI solutions on TED, and better on TED data. and then 3 work in progress or project ideas on which we have started working. Next, please. So some background concerning public procurement in the EU and what's the role of TED. Of course, we are talking about competition, transparency, and the superpower of data. That's where AI becomes absolutely relevant, as was mentioned by Professor Racca in the opening slides. So we are talking about some 2.5 trillion euros spent by EU public authorities on public procurement. It's about the 15% of EU GDP. The current EU legislations covers only a part of this, is estimated about 1/3, what is above the so-called EU threshold, for which special EU procedures are necessary, are to be followed. The rest is under under member state legislation. So one of the requirements for EU level procurement is the publication on the EU official journal. And TED is the website Tender Electronic Daily, on which every day the official journal is published with notices, public procurement notices, competition notices, and award notices, and other types of notices. And these amount to approximately 800 billion euros. So this is a very important component of the EU single market, in which TED plays an important role. And more we are trying to exploit the richness of data that every day are sent in notices via TED, because these are data which are valuable for any type of reuse, for macroeconomic analysis, for policy making. And of course, we are trying to implement open data principles on this type of data which are published in the official journal. And of course, here, the relevance of AI to exploit quality data is very, very important. Next, please. So the reform of EU public procurement, I will not be able to tell you much on the content, because we are, of course, in the process. In particular, my colleagues of DG GROW of the European Commission, with whom we collaborate, are in the process of drafting the new proposal, the new Commission proposal that will revise the current 3 public procurement directives. This is one of the priorities of the new Commission, of the Commission von der Leyen 24-29, and the, let's say, main direction of change have been announced in the mission letter. And you might have also read the so-called Letta and Draghi reports on the single market and on competitiveness, where the role of public procurement in reshaping the future of EU have been highlighted. And we are following a bit this approach. We are now, after the evaluation of all the directives, after an open call for evidence, public consultation, we are now in a stage that is called impact assessment, where the Commission is analyzing different policy options. And the current public announcement is that by end of June, there should be a Commission proposal. After that, of course, the legislative phase will open with Council and Parliament debates that might take at least 1 year, probably. But that is to be seen. Next slide, please. So the use AI is the topic of the moment, also within the European Commission, not only in terms of regulation. You are sure familiar. I guess the audience is composed mainly by lawyers with the so-called AI Act. That let's set up, together with other forms of guidelines, what we call a trustworthy AI framework based on the principle of lawfulness, ethical use, and robustness. When we use AI within Commission, we have put together a set of governance rules for AI, clearly following what prescribed by the AI Act in terms of prohibited practices, and applying also risk assessment to every initiative. And even when you have, for example, only, I would say, a transparency risk here for in the case of public procurement data published on the official journal, we are normally talking about public data. So normally there's not a high risk, but we are more and more using explainability notices to be absolutely transparent to the public. We are also using human in the loop as a principle. I'll give you some examples about this. And more we see that when we have contract provision for IT and AI tools, this is clearly defined in the contractual provision. Next, please. So I would start with the first case of use of AI, because this could be considered trivial, but in my view, is also should also be considered how the e-translation, how the automatic translation tools have gradually jumped into AI. Now we went from what was called rule-based translation to neural network translation. And since 2017 on TED, so that is to say on the official Gazette, a part of the official Gazette of the EU, we use e-translation. You know that one of the problems of the EU is the strong multilingualism. We have 24 official languages, and notices arrive in one language, but of course there's automatic translation through code lists for some standardized parts of the notice, but there are also free text parts, so in each notice, and this is since 2017 translated through AI-based translation network. I'll give you some screenshots of how it works. Next, please. So this is for signed-in users, and on the left you can see that you have a notice in Czech language, I believe, and you can request a translation. You will receive a notification via email. The interesting thing is that once translated, the translation will remain available for all other users. So in a way, is a on-demand translation. This has been the first use on an official Gazette of e-translation. And it's also linked to the continuous improvement of the quality of translation that clearly at the beginning was not sufficient to guarantee legal certainty. Next, please. Another example, second example, already in implementation, is not directly on TED, but is based on TED data. The op.europa.eu is the public publications office portal, and what we've done through an European Parliament preparatory action, there was a special funding targeting transparency public procurement. TED data have been used to provide an enhanced services looking at three aspects. One is the recreation of a procedure, because notices are often not easy to link to each other. You cannot link a prior information notice to a competition notice to an award notice, for example, in an automatic way. The tool makes it possible. There's again an automatic translation, in this case by default, of titles and descriptions. And quite interesting also, there is an enrichment of the procurement data, in particular for the so-called CPV codes. CPV code is the common procurement vocabulary, so the subject matter of the tender. And through AI-based inference, new CVP codes are generated that make it easier to search. But starting from the observation that quite often CPV codes have not properly used or are not reflecting the actual content of the public procurement. So is again an attempt to improve user friendliness for the user. Next, please. Here you see a screenshot. You can see the procedure linking the publication, the deadline, opening of tender, and the award date. And there's also a geolocalization of the tender and these improvements in terms of CPV code. Next. Another feature that I mentioned as one of the principles of good AI use that we are trying to implement or strive to implement are the so-called explainability notice. In terms of transparency to the user, this is the public procurement procedure that I just presented, has an explainability notice that explains how AI has worked on the original data, so to avoid the black box that was quoted before, which often we are faced with when dealing with AI. So these are the two examples that of implementation. Now I will talk about three projects that some of which are starting. The first two. So the first one actually is we are in a prototype phase, is the TED Data Quality Assistant. Here the problem is the quality of TED data. We already have some rule-based verification, validation, but here AI can provide a lot through machine learning and through the scoring of notices based on the content and possible problems that can be detected by AI. And of course, here again, human in the loop, the decision whether to publish or to reject the notice is done by a human agent. Next. Here you see where the TED Data Quality Assistant will be located. You see on the left, you have contracting authorities all over Europe that send notices every day, 3,000-4,000 notices. They go through what we call the reception, and at validation stage, we'll have a new layer, and then there is the publication on TED, and then the dissemination towards the public procurement data space, the TED Open Data Service, the OP portal that I mentioned, and the Open Data portal of the European Union. Let's come to the second example. Next, please, of project ideas. This is what we call entity resolution service. Here we are at post-publication. After publication, we make available data according to the linked open data standard, so-called RDF format, which is the one that, according to Berners-Lee open data scale, provides the maximum level of openness, so 4 or 5 stars, if somebody is familiar with the so-called Berners-Lee staircase to open data. Still, if you have bad quality at input, you will have problems also at output and analysis. One problem is that we are often confronted with an entity which has multiple naming and multiple instantiations. And I give you the classical example is organization names. Organization names, and the entity resolution, again, through proper machine learning, will be able to reconcile this plurality of entities. And there's a small slide explaining the next one, please, how it works. Here you have on the left the same organization, International Business Machine. I didn't know actually that International Business Machine is the IBM, okay? Actually, this is IBM Belgium. As a legal entity which appears in TED notices with here in this case, but probably there are many more different names, and through the entity resolution engine and the entity resolution service, always with a curator human in the loop, they are reconciled into a single identifier and a single entity. Next, please. This is a project idea that we started working on, but to be frank with you, this is simply so far in our strategy. So we are not really yet at project stage. So we are confronted more and more with an increasing quality of data, an increase in the granularity of data that makes possible to build complex search queries through. On TED, we have 3 search engines: a basic, advanced, and expert search that uses SQL. But we also have the open data searches that uses, as I said, semantic web technologies, SparkQL, entry point. This is something that for geeks is easy to use, but for maybe a lawyer or a citizen, a journalist, a researcher is not necessarily easy. So here the idea is to use, to give the possibility of building complex searches through AI, so that we are able to reply to this. And we also have a small example about this. Next slide, please. Yes, okay. This is on the left. You see our expert search interface that uses all the operators, as I said, not rocket science, but also not easy to use. And on the right, you have an example of a relatively complex queries of somebody that wants to know information about micro and small enterprises in Germany in a certain period, that simply by expressing this in natural language will be able to go either to our TED expert search or to the TED open data search. I think that's all I wanted to tell you. I conclude with some next slide, please. And this, I'm sure, will be made available. Our social media on X and LinkedIn, and our website resources. Next, please. That include also some tutorials and webinars for on the web. Thank you very much for your attention.
Thank you, Luca. So Caroline Nicholas is going to be speaking to us in just a second, Luca. And one of the issues that she'll be talking about and we're working on with regards to the UNCITRAL model law, and also in the United States, the American Bar Association is revising the model procurement code that's used in the United States. And also at the same time, the U.S. government is revising the Federal Acquisition Regulation. What evolves is a 3-tier structure. One is the law, and then there's a formal guidance, and then there is practitioner guidance. And the practitioner guidance in the case of the U.S. government initiative is actually being written by AI. They're taking the formal law and they're taking the formal guidance, and they're generating practitioner guidance, really with a view perhaps down the road to shifting the guidance, instead of having it centrally published, having it published by individuals. So essentially an individual says, I want to apply this formal law and this formal guidance to this kind of procurement. What is the practitioner guidance? Where's the publications office in that? Are you trying to make tools available to procuring entities so that they can generate their own guidance? Or are you using AI to generate general guidance, practitioner guidance?
Currently, we haven't gone on using AI for this, in this procurement area. While in other domains, I know colleagues are experimenting. For example, we have the so-called summaries of legislation, that where legislation is actually summarized and explained in a plain language. And I know that that there are consideration of going that direction. We work on guidelines together with the colleagues of DG Grow, for example, for contracting authorities on submitting notices, which is not necessarily an easy task. But we haven't yet gone into the use of AI, and thank you, because that's again could be an inspiration. I'll bring that with me.
Thank you very much. We're kind of in a unique experiment here ourselves and how we're running the webinar. So actually, my colleagues are all right around me. Do any of my colleagues, do you have any questions for Luca? No? Okay. Thanks very much. Okay, Luca, I think we're going to turn it over to Caroline. This is an excellent presentation. We really appreciate your time. Thank you again.
Thank you.
Caroline, the floor is yours.
Thank you very much, and good morning, good afternoon to everybody. I'm very pleased to be able to spend just 5 minutes telling you a little bit about reopening the UNCITRAL model law. Could we go down to the next slide, please? Thank you. For those of you who don't know what I'm talking about when I refer to the model law, it's an UNCITRAL, so a UN template for primary procurement law. It's designed to suit the needs of national procurement systems, and it's not designed for the EU or any other part of the world in particular. It's designed to be of universal application, and so it's quite different in scope then from the EU directives. Now, the current text, as Chris indicated, dates from 2011, and it was updated from the period of 2004 to 2011 to focus on introducing what was then viewed as e-procurement, something relatively new over that period. And it was intended to be a small rewrite just to allow for modern procurement techniques such as e-procurement to be integrated into a very 1980s, early 1990s text. The result was a 7-year process, and that led to the current model law, which is basically a framework law, i.e. it's very much the essential elements and processes needed for a national procurement law. What's happened now is that recognizing the issues that are on the screen, digitalization of public procurement and some new techniques or newer techniques, including current approaches to debarment, contract administration, bid review or challenge and so forth, UNCITRAL is looking at updating the model law once again. And you can see from the digitalization topics here that the risk, or perhaps the benefit, is that if we wish to really focus on what's needed with the digitalization of public procurement in the modern context, it will not be enough simply to take our current approach and make it more modern, previously going from paper to electronics, perhaps now for going from internet-based public-facing documents to a much more platform-based approach. So we don't know how far the review will actually go, but there are several things that we need to think about when doing a reform like this. And first is to focus on the fact this is a law. It's a primary procurement law. It's designed to be a framework law. It's not designed to be like the FAR, a comprehensive regulation. It's to set the essential procedures, the main elements that you need, transparency, competition, and so forth, and to make those real. Now, clearly, temptation will be, we have new technologies here. They're a bit scary. We're concerned about risks in use, so we will attempt to regulate them. So the first question really is, do we need to regulate them at all? What functions or new tools are we looking at? Or are they new ways of doing what we always did? And it's just a question of technology. We need to go into that analysis to see whether we need any new rules, whether there's any new regulatory risk. For example, if we think about AI as a tool that might make certain aspects of the, or fairly compliance-based aspects of the procurement process faster, is that anything really particularly new? On the other hand, if we're looking at using AI to take discretionary decisions, clearly that is new, but is it something that needs to be regulated in a procurement law? So all of those questions have to be analysed. And UNCITRAL has always taken the view that the functions in each step of the process are what should generate how the rules should look. So what is the function we're trying to do? If we're trying to say a tender needs to be signed, that's the function we're trying to provide for. And UNCITRAL has always said that we should do that in a technologically neutral way. We don't describe the technology, we describe the concept of a signature. And if we are still having signatures, but we're using different signatures from the ones that we used to, do we really need to change anything, or can we just keep referring to a signature and then update practical guidance, the sort of thing Professor Eukins was talking about, to make that more realistic in the modern world? Some particular questions that I think we'll have to be looking at very carefully is, how do we address accountability? Because in our procurement systems, we're based on the concept of transparency, competition, objective decision-making, and so forth, a lot of which feed into the accountability of the decision takers. Well, are we changing who are the decision takers? And that may involve some careful thought processes. We also need to think about what we need to learn from IT procurement, because AI is a second generation of IT procurement. And all of this, what you're hearing is, before we rush in to say, we need to update the model law, or we need to update any law, we're trying to identify what we need really to update, because one clear benefit of a stable regulatory system is that we get used to the system and we can make it work most effectively. So we want to avoid focusing on process efficiencies and thinking that those need to generate new procurement methods, new procurement approaches, if actually they are just process efficiencies. Anything that's different may require a different approach. So we want to keep in UNCITRAL the technical approach, the technical being the legal technical, the functional technical, and then reform as we need to, using that three layers of an elements of a system, that is the law, the guidance, and the institutions and so forth, to make it work. And I hope and I believe that UNCITRAL will be following that traditional approach in its review. And do we have one more slide from me? I think there should be one with the where you can keep abreast of all of the work that UNCITRAL will be doing later on in this year. With that, thanks very much.
Thanks very much, Caroline. If I could impose on Stefan De La Rosa with a question, if that's okay. I have a separate question for you. During our discussions today in the symposium, it became very clear that to understand how best to regulate AI in procurement, it would make sense not to just to look at the procurement processes, but look at, for example, data rules that the European Union, or we've gotten a series of questions here, Stefan, on the having to do with the EU AI Act. Would you, as someone who's very steeped in European Union law that's complementary to procurement, competition law, data law, do you think that it makes sense in the UNCITRAL review process to look beyond just what are procurement best practices, but also look at principles of competition and, for example, fair treatment under like the AI Act? Should we look at other areas of law as well when we're considering whether or not AI forces a revision of the UNCITRAL model procurement law?
Yeah. More generally, I think that, thank you, Chris, and thank you for inviting me here in person in Turin to this seminar. But more generally, from an EU perspective law, I'm really convinced that we have to put into perspective the traditional concept of public procurement, contracting authority, catalog, electronic support, collusion, fraud, and so on, regarding other branches of EU law. And in the general framework of what we call digital, we have to consider two sub-branches or two subcategories. The first one is regulation on AA, which is more an approach which is based on the legal qualification of risk. And one of the big issues, in my opinion, regarding AA is the fact that you won't find in the AA Regulation Act any specific reference to public procurement. The regulation is more based on legal qualification of risk, and the risk can evolve, obviously. So therefore, we have to put into perspective the subject matter of the contract, also maybe the process to award the contract, and the EU qualification, legal qualification of risk, whether is normal risk, high risk, and how this could evolve. So this is the first nexus that we have to put into perspective with EU law regarding the legal qualification of risk. And the other, I would say, nexus that we have to consider is more about the lex specialis that it has been enacted in the field of digital platform around the DMA, the Digital Market Act, and the DSA, the Digital Services Act. Because DMA and DSA are seen for now 2 years as a form of lex specialis, of specific rules of economic and competition law, specifically applying to platform, big platform, gatekeeper, core platform services, intermediary services, hosting services, and so on. So it is, yes, a form of class of competition law, but with very specific concept of competition law applying to platform. And then this is the other links that we have to make regarding EU public procurement law, how could it apply to digital support or digital platform in the field of public procurement. And the other issue of the two things, both II and DMA, DSA, is the form that this regulation apply regarding a criteria of territoriality within the EU, meaning that even if your provider is come from a third country, DMA, DSA apply to your provider. So for US company or third country company, it can be portrayed, but it's not true as a form of extraterritoriality, but it's more an issue of strict application on the territory of the EU of the two branches of regulation.
Thank you very much. Yeah, having gone through the process before with Caroline over many years, it is a very complex thing to try to take in a lot of learning from a system like the European Union and apply it to what is, and as core, just a law built on best practices in procurement. But it's very, very valuable. So,
yes, and another issue, because I heard Jessica Tilleman speaking of the so-called Brussels effect in her presentation of Brussels influence, what we call Brussels effect in political science. The issue is whether this concept that we have in the DMA, in the DSA, could be or not exported or could be opposed to a third country, could influence also a third country. And that's another issue, more about a normative form of influence of leader.
We very much had that. At the same time, when the earlier law was being drafted, Laurence Folio-Lalio, who's here with us, she was working with the World Bank. And one of the things that was very interesting was how, for both the European Union and for the World Bank, the other multilateral development banks, what was going on in the UNCITRAL law was so important because of this whistle effect you referred to, that it would have an effect on the shaping of the law, shaping of the rules in those other institutions as well. Okay, thank you. Okay, any other questions or comments from my colleagues? Okay, thank you all for really an excellent webinar. This webinar will be available in the next 24 hours. This video will be available on our resources page in Public Procurement International, and we'll be posting the slides within the next week. I want to extend a special thanks to Gabriela Racca, who has hosted a wonderful symposium here at the University of Turin and allowed us to experiment in this new format. Any last words, Gabriela?
Just say thank you all, because it was really a pleasure and a very fruitful discussion. So I think we will have to renovate the invitation for further occasion here in Turin too. Thank you very much.
Thank you. Have a good day, everyone. Take care. Bye-bye.